guess I'll start. The question is addressed to James. That's a very moving presentation. But you know, there was a story going around that Zul was lured into Singapore because he ran a story in the Straits Times a few weeks before the arrest. And so the theory was that they were trying to give him a false sense of confidence that he would have no problems when he came into Singapore. Is that something that the family thinks has happened?
I think the family doesn't see it that way. I think they were, probably pleasantly pleased that he had a chance to write in the Straits Times, and writing in any publication is great, especially if you're a graduate student, get your ideas out, and he was writing on ASEAN. So I think they just took it at that value. But I think where their concern was Zul was participating in a WhatsApp group with acquaintances. I don't know whether they are friends, but definitely acquaintances in Singapore, actively discussing and sharing vividly, his plans to come to Singapore and so on. The family's view is, I think someone from that WhatsApp group probably gave advance notice of his crossing over to Singapore, because their feeling was they were very well prepared and organized to receive him and the family, and there were abundant of officers, and that's their feeling.
My point being, when I first heard that he was detained for 2 years, my first thought was it must be for alfatiha.com, when he had this expose of the Ho Ching miracle, questioning Ho Ching about her handling whatever stuff in Temasek at that time. And there was a charge of criminal defamation against him, his computers, whatever, taken by whatever. And then he managed to, I think, leave for Australia. So I think this goes along with that. Because I don't know him as a terrorist. Although I did read in Citizen Online, somebody wrote to say he had a ISIS flag behind him, but that is actually the Muslim Shahada, which says, I believe in God and I believe Muhammad is his prophet, which is in Arabic calligraphy. It might be difficult if you don't read Arabic, worse if you don't read calligraphy, because that is what every Muslim will have in their house. So very strange things are there. The other thing is, I want to know what has happened to the Lee Kuan Yew promise that when Singapore is a modern nation, we have no problems, etc., that we will have fundamental liberties. We will have human rights, and not just limited to economic rights. So is that promise still somewhere in the air?
I don't know what to say. I guess I just take it as a comment. But I think the one point is the 2001 issue, because you can see, if you look at the hard numbers, and we have put it down as 126 Muslims arrested, both local and foreign, from 2001. And Zul has been coming in and out of Singapore in between over the years, and he has just not come in, in the last few years. So there must certainly been a change in internal policy in terms of what parameters within which they might want to take in someone, because he has been, intermittently coming out, and also having some of the earliest issues since 2001 mitigated somehow. So I think there is a fair question here about why now.
Can I answer Sal's question? What Lee Kuan Yew said in the 50s, I don't think he meant it. what he said. I think this is, I quite agree with Dr. Posukai in his book that he was just trying to lure the left to join him, and that whatever he promised, he knew that he was going to breach it. Okay? Thanks.
I actually posted a particular comment in Lee Selum's Facebook that if Zul was really a terrorist, he was based in Australia. So why wasn't the Australian authorities being notified? And if he was notified, if the Australian government was notified, why wasn't there any actions taken? And if the fact that he was a PhD student at National University, that poses quite a danger for the students that he's teaching or the people that he's been influencing with, or so-called. So that's a question which I think, and the fact that they are actually asking for his Australian passport, financial information, it's quite obvious that the Singapore government cannot get access from the Australian government for some reason or another, because perhaps the evidence that he is indeed a member of a terror group is probably unfounded. It's just my comment. And the fact that Zul was actually here last year, so why now? Thanks.
Maybe take more questions, then we all can interact. Yeah.
Yeah, my question concerns Solang's first slide. I think she brought out that quite a number of children of ex-detainees are now participating in the establishment. What do the panelists say about that? I mean, is it actually an endorsement of the ISA? Because since their own father so-called suffered under it, but then in the end they also joined back the people who created this. So does it mean that actually they agreed that maybe their fathers needed to be tamed and restrained, and that since and it's actually good for the nation? Your comments, please.
Any more?
Whilst I wish to exercise my right of silence on this, it's very hard to surmise this, isn't it? Really, what are their motivation, and is it really fair for us to actually guess that even?
Yeah, I guess that's a question really to the children, so we can't really speculate. But I want to address the first question just now. I think the bar in Australia and Singapore is different. Even in terms of the period you can detain someone, right, is very, very short. In Australia, you have to show due cause and so on. So I think the bar is different. And I go back to what Solang said in the presentation. So there are other laws within Singapore that one can evoke and use to pursue these things. But I think it's convenient to have a catch-all approach, and using the catch-all approach to find more incriminating evidence and to see if somehow some linkages can be made. That's my sense also here with the detailed inquisition with the financing and the transaction. So I guess we might see, as it's in the pattern with other detainees and how they were prosecuted, we can see one possibly to have contravened some law and then sentenced to so many number of years, or two, deportation, right? Because he has two passports, so you can't have dual citizenship. So maybe for not declaring dual citizenship, there could be an offense there. Usually, generally, it's a fine, but in this case, we don't know. And then after that, deported.
By the way, James Puducherry was the uncle of Janelle, not the father. But the father was also once detained. Dominic Puducherry was detained in 1963. It's very interesting. Going on with James' point that Zulfikar surely was under some very severe pressure in detention. All of us went through that in '87. We were told, we were promised this, that, and the other. And then when the time comes, how come the promise never got materialized? So they give a lot of false hopes, but they're quite happy to forget that they once promised this and that. And therefore, this threat that, once you go out and you campaign, it's worse for your case, you stay here, like Chataipo, 26 years, the key will be thrown away. It's pretty common. For us, we went through that. When the international organizations campaign for us, they tell us, and then we get a bit worried whether our detention will be longer because there was so much campaign outside. But quite frankly, they are on a winning side. If you don't make noise, nobody knows about you. Who cares? And Singaporeans won't speak for you. Singaporeans are generally very law-abiding. So if you ask me whether international campaign should continue with their campaign, I say, yeah, well, go ahead. No, I think it's their right to speak. Why shouldn't they? Yeah.
So I also had a question, if there are any others, but I just wanted to add on the question. So following on James's point about the different bar between Australia and Singapore on what's necessary to be proven before action can be taken, are there any best practices from other countries that we can look at in dealing with terrorism? Because one of the things that is used to justify the ISA is that every country is grappling with this problem. Look at France, look at US, and some of these countries are maybe moving towards illiberal policies. If only they had the ISA, they could deal with it. So what are some of the best practices that we could actually look at?
This is being deliberated and talked about under the Universal Periodic Review, because that's where the debate about best practices is. Generally 2 points. First, that if it's terrorism-related issues, then have clear legislation that marks out the offences with the appropriate punishments, due process, and so on. So that's the first thing that's brought up. And secondly, there is concern about arbitrary detention, indefinite detention, the fact that there's no open trial. So these are the two elements. So you'll find in the Universal Periodic Review that discussion is rich as we try to sort of establish some global standards, and not only civil society groups, as I highlighted earlier in the Singapore case, over 2 rounds. Other governments also raise these issues, and Singapore during the UPR was questioned also by other governments on this point. Singapore, of course, always claims exceptionalism, right? That its position is unique, and that it has to manage multicultural differences and things like that. So it has a stock position, and that kind of comes up often.
Yeah, under the United Nations Declaration of Human Rights, 1948, we all know that the declaration was that everyone is entitled to a fair and public trial. So why this exception is because of the emergencies, they say, but actually when in 1948, when Singapore accepted the emergency regulations, there was no emergency in Singapore. The emergency maybe was in Malaya, but the governors over in Singapore felt that since Malaya has this emergency, we better get ourselves prepared, and therefore we would have this emergency regulations. And it was supposed to be temporary. It was 3 months. The governor would make a proclamation and so on and so forth. But the emergency declaration has become law today, and we are stuck with it since 1948. We are stuck with it. It is really tragic for us. Now you ask about what other regimes have this kind of law. Well, Malaysia has already abolished it. In the UK, they have the Terrorism Prevention and Investigation Measures Act 2011. 2011, I think. Yeah, this was following the 2001 the Twin Towers bombing. Under this regime, nobody is detained for indefinitely. all that they had are restrictions placed on a particular person. For instance, they are called in to be investigated and they have to follow the criminal law regime, i.e. the investigations and interrogations would be videoed by the police authorities. And then the government had to appoint a senior lawyer for these so-called interviewees, and these senior lawyers have a chance to look at the confidential documents, maybe not all, but most of it, and then they can argue the case before a tribunal, who can then make an order that the particular person has to be under some restrictions, like what we have in Section 8 of the ISA. But they are free. They are free to move around, and of course they have subject to working hours. They have to stay at home from certain hours. They have to be back home by 10 o'clock or something, and they have to report to police station. Maybe some inconvenience, but nothing like us in Singapore, where we have detention without trial. First of all, for 48 hours. And then never produce in court, and then go on to another 28 days, 30 days of detention without an order, without the court knowing what is happening in detention. I think this is totally unjust. And Zulfikar should, if he has committed any offense, should be charged in court or should be released immediately. This is my view.
Hi, I'd like to understand, if someone is under detention, what's the soonest time you can see a lawyer? What defenses could be possibly posed since any evidence will be classified in national interest? And the second point is, we mentioned earlier, this is James, that there are accounts in Australia seem to be frozen, right? But the Act is a Singapore Act. How does it have extra territorial powers as such? Or is the Australian government also cooperating with ours?
We'll just address the financial question. No, the Australian accounts are not frozen. What the family needed were two things. One, a PIN number to operate and withdraw money for daily living. So that was one request, and this was the first early request, and it was accommodated. It took a little bit of time through the liaison officer, going to the case officer, and the family simply received a text with a PIN number. So that's the first one. Next was the family wanted to operate some of his accounts to manage the payment of the bill, because a lot of things is in gyro. So what they needed from Zul was permission and an authorization letter allowing the wife the authority to operate those accounts, because because of privacy laws and best practices, she's not able to access and operate those accounts. The request for that authorization letter was made. She was informed that it's not possible for her to receive the authorization letter simply because, since he's under detention and being investigated for terrorism charges, he comes under this concern as well, this particular act. And because of this particular act, such authorization from Zul will not be allowed. So she's then stuck with not being able to operate the account. And I think what she has done is then approach local lawyers in Australia to see how to manage this. I think her main concern is not is the accumulating interest or charges that can snowball in Australia. I think she wants to manage that, and then meanwhile trying to find solutions to to pay the bills. For the first question, I'll pass to.
As to the question of what is a reasonable period of access, in the normal situation, the courts have defined that 21 days is perhaps the maximum that you can deny the access, provided that the state show sufficient reason It's not like last time that the state can simply get a carte blanche, approval from the court. But the tricky bit here is that the ISA is before it's not subject to judicial assessment in the courts. So the person is not brought before the court. So what is a reasonable period? Still the Constitution should protect, the Constitution interpretation of 21 days should be the reasonable period. This particular bit is not really tested yet. But if you look at Article 149, that the amendment where it is that within the 149, remember there's Article 9, if any acts which comes inconsistent with Article 9 and your right of reasonable access comes under Article 9, so that could be denied. But I think generally they allow reasonable access, from what I understand, maybe Teo Solang, reasonable access to lawyers.
Reasonable access in the case of Limau Singh, who was detained in early 1970s. His lawyer was David Marshall, and David Marshall wanted to see him in detention, but he was disallowed. So he took up a habeas corpus application. Wee Chong Jin said that, the Chief Justice then said that reasonable time, it's reasonable time, and 21 days, it's about that time. I think Marshall saw his client after 21 days. For us in 87, I think we saw our lawyers maybe a week after, I cannot remember very well, but maybe a week after, and at the same time our families were allowed to visit us. And then it's not as irregular as Zulfikar's, but we had a weekly visit from the families and from the lawyers.
Sorry, I have to make a clarification. In relation to the Article 9.1 exclusion is actually judicial review on the reasons for detention, the exclusion of that, not so much of the right of access to counsel. So Limau Singh's case is an ISA case, so that itself is a case in point. So it will be applicable the 21 days here as well. If a person is denied access beyond 21 days to his lawyer, so that the case is applicable here in this instance.
Counsel do? What defenses can you? There's no charges, so what defense?
No, the question is actually basically due process within the limited context of due process. Safeguard is only given. You can take your client's instructions and all that. At the end of the day, you present before the advisory board here within another 14 days, right?
As we have informally.
Yeah, informed. They have 14 days to, appear before the advisory board. So. You have no access to court. Basically, your recourse is to the advisory board.
But in this particular case, I think with regards to the family narrative was initially, Zul was quite clear that he wanted to, conduct his own defense because perhaps there was no clear understanding what the review board is all about. Perhaps there was a sense that could go before the review board, defend and clear the name. But the family was reminded that one can write in, a lawyer can write in and ask to represent Zul, but then Zul has to agree, right? So if lawyer A writes in, the family appoints him, and then the lawyer writes in, and then Zul inside says, no, I don't want, then that's a problem also. So these are kind of the mechanics of it. I think now there is a request. So I think if there's a lawyer, then there's another visitation over and above the family. So right now, I think the key thing in terms of zooming in on this case is really to highlight, over the 126 Muslims that have been arrested under ISA or detained or restriction order in the last 15 years. We don't know much about them. We don't know much about them, their family, what's happening to them, this is the first case study where we have some fairly open information. And that gives us a window to kind of investigate and find out what else is out there. I think we need to collate more information to understand, because this is a phenomenon. That's why even the seminar was, entitled From Communists to Terrorists. It's a phenomenon of Singapore's modern history right now in the last 15 years, and I think it's important to kind of understand the trajectory around it.
If I may add to that, I tried very hard to obtain some information about the 126 Muslims who were arrested, but I got nowhere at all. So really, we do not have any information. But right now, James has given us some information. That's very good. I hope that the others will come forward. With regard to the advisory board, all of us who were detained in 1987 were discouraged. The 16 of us were first arrested on May 21st, 1987. And all of us were discouraged from making an application to the advisory board. The ISD officers used to tell us, it will make your case worse, so you better shut up and be good. Leave it to us, we will recommend your release. After 16, then I was the only person who filed an application to be heard before the advisory board. And the reason why I did it was that I was so angry with the grounds of for my detention. They said that I was manipulating the Law Society. So I was very, very angry with that. And I wrote, the grounds are very brief. When they give you the grounds, it's like you manipulated the Law Society using it as a pressure group. And then you use Communist United Front methods to I don't know what, to go into the Workers' Party or something like that. So I used the opportunity to actually write my defense on record. And that was what I do. Zulfikar, without a lawyer, can do that. He can prepare this paper and submit it to the advisory board. After all, the advisory board is only advisory in nature. Whether you succeed or not, it's up to them to advise. Although if they advise, and sometimes this is very technical or rather political, that sometimes they recommend, and then the government listens to their advice and release the prisoner. I think in 1991 or 92 there was an amendment to the presidential power that if the advisory board recommends the release of a detainee, the president agrees with it, then the government must release, right? I think there's an amendment to that. So the fact that detainees were always subject to pressure that they do not appear before the advisory board is very common. When I was one of 16 to file that application, and subsequently another 6 were arrested 1 month later, and 3 of the 6 filed an application for the record, which is good.
I just need to know technical thing. If he has already detention order for 2 years, why are we still questioning him? Why are they continuing the interrogation? So it's plus 2 years of interrogation. One. Secondly, I think by saying his wife should not come, his mother should come, that could be some kind of emotional ransoming and so on with the mother. So that's a problem. The third thing is, once upon a time, a long time ago, I heard that the Muslim families met and they had, on humanitarian grounds, had family support groups, but they were visited by ISD, and then nobody knows what has happened. So the experience in Malaysia is the family support groups are multiracial. They're not just one single community. In case that community is marginalized and discriminated and have government jobs, it becomes difficult for them to actually mobilize. So it becomes that. The other thing is
what I've seen today by MRE was saying that PAP actually have enacted laws, changed the constitution to in such a way that it becomes a concentration of power in the ruling party. And you must, from the voters' perspective, when I talk about Zul's arrest recently to some of the intellects and fellow opposition party members, they say that when it comes to the security, we must trust the PAP party. That is my concern. Second one, On the political front, when we want to go for abolish ISA, for example, we campaign for that. The response from the ground is that we still need it because we have this besieged mentality within the voters. We are constantly threatened by our neighbors, by the communists. Now the communist is gone, by the extremists, terrorists. So we have to give something in return. How do we actually assure the voters of creating a viable system that balances our interest, the voters' interest in having peace and prosperity for the security of the nation, as well as a proper check and balances within the system? I think this should be the way that politically we should go forward. Instead of just saying that abolished ISA, that will scare a lot of people off. But if you say that we must have a separation, a proper separation of powers within whatever terrorism act and whatever the act that we want to replace the ISA, I think functionally may want to take this opportunity to actually think through how to go forward.
First of all, I think we must realize that we are citizens. And as citizens, then the question must be, what type of society do you want to have? A society that is run by the rule of law, or a society that is lawless? As far as I'm concerned, ISA is not a law. ISA is actually a suspension of law, because ISA in the current form is actually arbitrary detention without trial. So it's actually suspension of all law. If you look at the history, it is exactly when you use the emergency to suspend law so that you can administer a situation that's chaotic. But now we are already 51 years, right, into a so-called nationhood. So it's a question of, as a society, as a citizen of a society, what type of society do we want? A society that is ruled by law, rule of law, or a society that is lawless? And I will put it this way, the people who support ISA, I would say that they believe in lawlessness.
I think that the concern is, I am concerned if something is done in my name and I don't have anything to say on it. This arrest is done in my name. The other thing is, I think governments cannot operate in secrecy. ISA protects secrecy of governments. It does not make them accountable. I'm so happy to hear judges are active. I wouldn't say the other word because people get nervous with the other word. But the fact that they are trying to reclaim, take back, or claw back, as Hong Kong activists say, they are clawing back their rights. Because unless you also speak for the judiciary and support them in the right ways, the judiciary cannot do much. They wait for Parliament to tell them, you have no say here, you have no say here, you have no say here. So I think it's also good if citizens support judiciary when they do the right things. So judges know that the crowd is with us. We are going the right way. We are trying to claw back our separation of powers. Since we have a unitary government, since we don't have a viable opposition in Parliament, therefore the judiciary has to reclaim its role. I think citizens must do that, must have that engagement. Of course, it's not going to happen in the Straits time, so to figure out where else it can happen. Thank you.
Like what Salvia has mentioned, there is this judicial trend towards recognizing individual liberties, and at least I'm happy that in 2015, as recent as that, the Chief Justice has recognized the basic structure of the Constitution, and I hope it can progress from there. And of course, the fundamental test is still the subjective test, but because of this movement which is taking place in other constitutional challenges which are non-IAC related, this judicial sentiment hopefully will move in the positive direction. And Salvia, once we are in the climate of talking about contempt of court in negatively influencing the judiciary, but you have given a fresh perspective to positively influence the judiciary.
I guess my sort of final remarks is really to come back again to the numbers. In the last 15 years, we have one straight line down 126 Muslims, both local and foreign, who have been arrested, detained, restricted under the ISA. It is a shift, it's a phenomenon, and I think there's not enough research and understanding in this 15-year body of arrests and the impact. I think there have been discourses on sort of a statist approach to the phenomena, talking about terrorism, extremism, radicalism, from the perspective of state, from people who work for statist institutions, think tanks. We also have sort of legal approaches. I want to kind of look at more sort of action research from the family perspective to try to then have a more comprehensive understanding of the situation.
Yeah, answering Mr. Goh, the question of whether we should continue to ask that the ISA be abolished. You think that it is too extreme a request to make. But really, maybe a decade ago, we don't hear of the word human rights. It's like a very dangerous word. A decade ago, you don't hear about Amnesty International. You don't want to be associated with Amnesty International. But look at the society today. We recognize that there is something called human rights. Even the judges refer to that. And Amnesty International is okay. So are the other organizations campaigning for human rights. So I think it's a question of speaking up, and people somehow may get used to it after you repeat it a number of times. And then as far as the judiciary in helping us, of course the judiciary, it's very hard for them to be giving up a judgment and then facing the consequences. Although in the Constitution, there is separation of powers. Because the consequences can be so great. If you have a law society that will not support the judges, and the people that will not support the judges, in order to help ourselves, then how do we expect the judiciary to be giving us good judgments? I think we also have to be very realistic. Everything must move in tandem. You don't have the people moving and then getting under ISA and nobody bothers because everybody forgets about who went in and how long he's been staying there. I think this is very unhealthy. We all should be concerned about each other, be it citizens, legal profession, any professional bodies, or wanting to ensure that the judges are independent and the judges have the power to be independent, right?
Yes. Well, thank you everyone for coming. It's a round of applause for us.
I'm so sorry that I would like to just, those who are very concerned about any, if you don't have the right to go to court, what we call the standing to challenge any particular provisions and all that, like for example, the constitutionality of the ISA or the elected president. And you can, as citizens, remember that there's Article 100 in the Constitution, that you can petition the president to convene a constitutional court to decide on constitutional issues. So it also, that the reason why I'm saying is this: if you feel very strongly about a particular constitutional issue, whether it's elected president or any other constitutional matters, as citizens, you can petition together under Article 100 of the Constitution for a constitutional court to be convened.
Okay. Thank you, everyone, for coming. Just two more things. First thing is that we would like to thank the panel of speakers for being with us, and I would like to invite Director William Yap, Director of F8, to come forth and give a token of appreciation to the speakers.